Hello and good afternoon, everyone. Welcome to Gagasan Mahasiswa Undang-Undang Sabah's very own webinar series, introducing legal perspectives from Sabahan advocates. Today, our second session is premised on civil litigation and trial advocacy, where we will be discussing what it takes to be an advocate and solicitor in this very wide area. I'm Brenda, your host for this afternoon, and together with me is my co-host Legerod, who will also be moderating the Q&A session with the audience later. I invite Legerod to list down some ground rules to keep in mind for this webinar session.
Hello everyone, nice to see all of you today. I am Legerod, your co-host for today. As everyone here knows, wherever we are, whatever we do, we are subjected to certain rules. Now, here are the ground rules for today's session. For your information, today's session comprises of two parts. The first session will be for 1 hour between the moderators and the speaker. The second session will be a Q&A session for 30 to 35 minutes between all of you and our speaker today. All questions from the audience will only be taken and answered by our speaker after the first session. Feel free to type in your question in the chat box along the session or during the Q&A session with me later on. Also, please be mindful and respectful of your questions directed to the speaker or your comments regarding the session. In the meantime, sit back, relax, and enjoy the session. Back to you, Brenda.
Thank you, Legerod. It is with great pleasure that I introduce our esteemed speaker of the day. We have none other than Mr. Lau Cheung Hoon, a civil litigation lawyer with experience in prominent areas such as arbitration and commercial litigation.
Hello, hi Brenda.
And so, without further ado, we will kickstart the session with some interesting questions. So, Mr. Lau, our first question is, what made you decide to venture into the area of civil litigation in the first place? Was it an interest that sparked during your high school days, or did it develop along the way when you were in college or university?
Okay, let me be quite honest, lah. Actually, my venturing into this field was quite accidental. I had a serious stammering problem known as they call it blocking. Since primary school. So imagine like 10-minute class presentations in high school will take me 40 minutes just to work through the problems I had with my speech. So now can you imagine this is quite a humiliating problem. So back then, right, it would have never occurred to me that I would be standing in front of a courtroom with that problem. So when I was when I went to university, my interest was initially in public policy. Now specifically, right, in science policy, with an interest of whether innovation ideas are subject to the laws of Darwinian natural selection. However, as you might know, being law students yourselves, that public policy, right, and law, right, they are very closely related areas. So policy, can be implemented in many ways. But one of the tools, right, available to policy, right, is law. So now, given my stammering problems, right, it would not quite be natural for me to transition to law, but now my mother, since she's a Chinese boomer, she has other ideas. So imagine she essentially scammed me into law school. So I was there partly to please her, but partly because I'm also a naturally curious person, as to what lies beyond that, you see. So now it was this same curiosity which actually led me to civil litigation. But more than that, right, there was also this deep need in me, right, to confront this fear, very deep-seated fear of not being able to speak. So you think about it, right, during my first ever solo argument before then Datuk Ian Chin, it was a double appeal before this judge. He is a judge he has a temper, if you've heard of him. So what kept me awake, right, before the hearing that night, right, was not whether I would actually win that case. It was not about being scolded by the judge. It was not about the quality of my prepared arguments. It was that overwhelming feeling that that I cannot, when I open my mouth, right, nothing will actually come out. So that was what I had to confront. But here's the thing, you know, for you. So at that crucial moment, right, you know, when you are standing there at the cups, you know, of your personal Rubicon, you know, and you push through it, right, you are liberated from the past problems, you see, and you know, and oh, by the way, I won both of my appeals. So that's how I'm here today. I just continue on like that.
Oh wow, that was a really interesting journey. I mean, I like how you said it was very accidental when you explored this area, you know. So it was really nice to hear that. And so our next question is, would you say that legal practice in Sabah is relatively a little bit more relaxed than that in West Malaysia? You know, because I've heard that in West Malaysia it is more stressful because the lifestyle there is more fast-paced compared to Sabah, which is a little bit more steady. But what do you have to say about this?
Well, I think it's too generalized to compare Sabah with West Malaysia, so because it really depends on your geographical location. Is your practice in the capital city itself in KL, or whether it's in a secondary city, or whether you're in a small rural town? It makes a lot of difference, you know. Because I have done an attachment. I did a 5-month attachment in Sien de la Mor in Penang last time, and now this branch is closed down already. But I didn't think in terms of the work-life stress difference, or that is too much difference. In fact, I find that now in KK, in Jayasuriya, in terms of the stress levels is actually higher compared to what the kind of work they did in Sien de la Mor and Penang in those days. So yeah, it really depends, you know. Now, if the second thing also, it depends on who you're working with or for, because if you are working with a demanding senior counsel which has too many cases on their plate, well, you're going to be feeling the hectic, you know, thing. But if you're working with a part-time litigator who kind of selectively accepts less contentious matters, again, that would make a huge difference regardless of where you are located geographically. But now, if I'm permitted to assume here, I think what you meant here was a reasonably successful litigation practice in Kuala Lumpur when compared to Kota Kinabalu. Then certainly I think practicing in KL, right, all things being equal, would be more stressful. You know, I'll just give you an example from my experience. Indirectly, right. So now a few years ago, right, I appeared before the Court of Appeal, sitting here in Kota Kinabalu. Now, for those of you who are not aware, right, the appellate courts travel around Malaysia in a circuit, you know. So here they hear cases in Putrajaya, they hear cases in Kota Kinabalu, they hear cases in Kuching. So it depends on where the case arises. So now in the case that arises in Sabah, you'll be heard by the appellate court sitting here in Kota Kinabalu. So what happens is, of course, this whole panel of judges, 3 of them, with all their supporting staff, with all the documents, they will fly the whole lot of them over here. You know, these days, right, that practice is less, you know, because of the pandemic. Now they do most of it by Zoom hearing, but they are now starting to come back again. You know, they like it here. So in my case, right, this client of mine was a large publicly listed developer based in Kuala Lumpur. So they're advised by a KL-based law firm. So during this hearing, the client sent in-house counsel, and they had a large team of them. So they sent in-house counsel, and she was an ex-litigator with more than 10 years practice in a KL firm. And they also sent the senior partner of the KL firm who was advising them with her. So there was 2 of them. They can't sit with me, but they were just sitting in the gallery behind and watching. But when they found out who was the judges on the panel, and we only find that out on the day itself. So when we found out who was one of the judges, they got a bit worried. So both of them started telling me these horror stories about how this particular judge is, how difficult she is, how fierce it was. And she said, you know, this in-house counsel said, you know, I appeared in Shah Alam, you know, this case with one of my colleagues, and this judge beat his head off. You know, so she's a tough lady, and that didn't help my anxiety, not one bit. See, so for some context, right, we were waiting that whole day. You know, litigation, right? One thing you may not be aware is that, you know, it involves a lot of waiting. It's, you sit there, you wait the whole day waiting for your turn. So in this particular case, I've been waiting since 9 a.m. in the morning, sitting in court. And my case was only called up at 4 p.m. in the afternoon. So that was like, yeah, the waiting time, I think you could have flown from KL and reached Dubai, at that time. So think about it. So the panel was really tired. They had a long day, so after hearing all these things, not great. But now, what do you think happened when the judge actually heard my case? She was the sweetest lady ever. She was patient, she was calm, she was reasonable. I won my case. So my KL colleagues was happy, but they were very puzzled and they were amazed. So they said she was like a different person. Last time she was not like that. What happened? They said. So I told them, I don't know. I think it's our air, Sabah air. Since you're here, breathe it in, breathe it in. Do you feel calmer already? I don't know why, but you see, same judge, different place. It makes a lot of difference. So they're not like that. The KL judges. They are under a lot of pressure. They have a lot of cases. They are hot. They are short-tempered. So when they come here, they are well rested. It's different. So these two colleagues of mine from KL, right, was amazed to see a completely different judge when she's here.
So in other words, it is depend on the whether or not the stress level is actually depends on who will be judging this case later on, whether this judge is a strict judge, and then so it depends on that.
It definitely depends on the location, because this is the same judge, same judge, different location, different personality, So definitely being in KK here, well, it helps the mood a lot. Which is good for me as well. I was very happy.
I'm glad to hear that. So, Mr. Lau, if you don't mind, is it possible if you could walk us through the civil litigation process from the preliminary preparation up to the trial in court?
Okay. All right. This is actually quite a lot to talk about, because I think this topic alone, you can probably take up half a semester in the subject. But so I'll try to go very, very quick, very brief about it. So anyway, the whole process, right, can be roughly divided into 5 stages. I'm talking about here only about civil litigation in the courts. I'm not talking about like statutory adjudication, other forms of, just the court process, right? There are roughly 5 stages. The first thing, right, is what we call the pleading stage. This is when you first start the case, how you start the case, filing the writ of summons, So this is where you get the facts of your story straight. You identify the issues being disputed. You decide what you want from the court, what you want to ask from the court. So the rest of the process will be pretty much guided by your pleadings. So it's quite important to get this part right. So now, secondly, after that, the second stage is the compiling and gathering the evidence. Now, in civil litigation, documents, especially good quality documentary evidence, is 90% of the game. Now, a lot of the time will be spent making sure that your client has all the evidence you need. Now, if they don't, you might need to require to obtain them from other parties or from third parties such as expert witnesses. Now, although I call this a second stage, right, but your client would have started this process even before they met you. They would have something already in front of their courts. But this process is an ongoing process. So even though I call it stage 2, it starts before the thing. It goes sometimes all the way up to the trial, and in very rare cases, even when the trial is ongoing. So this is documentary evidence, very important. And the other part now, of course, we talk about oral evidence. Oral evidence is when the witness physically goes into the court, takes a stand, and tells their story. So this one is also important. So you need to interview your potential witnesses several times to get the story straight, because they're going to be challenged by the other side in the court. So repetition is key, because human memory is fallible. So people can suggest it, they can remember things, remember properly. So you need to do it a few times. Now, if you have the luxury of having more than one witness capable of giving the same evidence, right, you have to exercise a judgment call to pick the more suitable one. So that's the second stage. Right? The third stage, right, is about presenting the evidence. So there's no point, right, if you compile all this evidence if you don't present it to the court, right, in a cogent and coherent fashion. This is very important because obviously you have a judge up there. The judge needs to be able to see those documents, those letters properly printed out, clearly, easily found, easily located. You don't want to frustrate him. You don't want to get the judge angry. Because nothing like peeves them all more, right, than looking for documents they cannot find. So there are a lot of cases, and you try to help them, assist them, making them the job as easy as possible. So you have to organize them properly. You have to organize your documentary evidence into bundles, into trial bundles. You need to organize your oral evidence into witness statements. So this has to be given to the judge, has to be given to the other party, right? So they can have to look at it before the trial starts. So of course, the fourth stage, right, is the part that most people see. That is the part that when people think about lawyers and trial lawyers in court, it is that part, in the court process. But as you can see out the 5-stage process, right, that only comprises, right, 20% of the total time spent. It is only the what people see is that, but most of the time you are not actually in court. This is something, when you're in court, of course, the process itself, when the trial begins, this is a very quick, very, very brief rundown of the process. Essentially, the plaintiff before the plaintiff starts the case, the judge will start the case by, he takes cognizance of all the documents before them. The parties' pleadings, neatly organized into a bundle of pleadings, the bundles of documentary evidence that we rely on during the trial, the other documents the parties have relied on, such as agreed facts, agreed issues of the trial, all these things. Now, after they have done that, then the plaintiff will start their case. They will call a first witness. So they will start this by what they call examination in chief. They will lead their evidence through this first witness by showing them their witness statement and placing this into evidence. So they may also ask the witness additional questions. Now, once they are done, the defendant will commence their cross-examination questions, where they will essentially try to mostly to elicit truth, facts. They will test the credibility of the other side's witness, all that. So now, after that is done, now the plaintiff will be allowed to re-examine their witness relating to only the questions which was asked of their witness during cross-examination. Now, after that is done, the witness is then released from his witness duties. Plaintiff will then call their second witness, and then the process will repeat again, will continue until the plaintiff's witnesses are all done. Now, at this point in time, the plaintiff will inform the court that they rest their case, and then the defendant will then start their case by calling their first witness, and then this process will also continue until the defendant closes their case. So that is essentially the fourth stage in a nutshell. Now, the fifth and final stage, right, is that once the parties have closed their cases, rest the cases, right, the judge will then direct the parties, right, to file their closing speeches or submissions. This will, in these days, be by way of written form. There will not be two. There will be a main submission that goes in, followed by a reply to the other side's submission. But the judge may likely then schedule a day for oral clarification. Now, this is something which is very different from the old days during the senior lawyers' times, because in those days, a lot of the submissions they were done orally. They're not in written form. They literally just, the moment the trial is over, they stand up and then they give their speech straight away. These days we don't do that. We do by way of written submissions, and the oral clarification is done only after the submissions are put in. The judge will normally read those submissions. If there's any points which they are not clear, they will raise it at that point in time. So then after that, judge will normally also then schedule a date to deliver the ruling. And that's it. That's the whole process essentially.
Yeah, it's actually very compact, because very compact process, right? The next question, what some pointers to keep in mind as a civil litigation lawyer in terms of attitude, conduct, and work ethics?
That's also a very, very broad question. But since we're talking about civil litigation and conduct and cost, let me just focus on one of these areas which I think is not addressed enough. One of the major peeves of many judges, right, are lawyers who do not know the proper courtroom decorum and etiquette when presenting their cases. So first thing first, right, you need to make sure that you're dressed right. So lower courts and all chambers, wear suits. High court, appellate courts, you need to remember to wear the robe and the bib. So be attentive to your personal grooming. I think, if you dye your hair bright orange, that's great if you're a K-pop idol or something, but you will know that you will only win your hater on the bench. So you don't want the judge to hate you. That's not a good way to start the case. Bad first impression, So personal grooming important, So secondly, of course, you need to, some junior lawyers not exposed to this, but they need to know how to address the judge. I have heard judges complain to me saying that this who and who doesn't even know how to address me properly, and they are just not right from the back. Which is not a good way to start the case. So lower court judges and registrars, they are your honor, honorable judge or deputy registrar. High court, appellate court judges are lords and ladyships. My lord, my lady. So if you're a lady judge, do not address her as my lord. She's not going to be happy. I'm not a man, she will say, and then you're going to lose a few points there. Don't. Very easy. Don't lose this kind of points. Easy points, like your exam and that. Don't lose the easy points. So if in doubt, you can also use the Malay addresses. You can call them Yang Arif, or when it comes to the chief judges, you call them Ahmad Arif. You can use that as well. So this will the Malay language in the sense will take away the gender. So you don't have to think about the lord and lady because they are all Yang Arif or Ahmad Arif. That's one way. So thirdly, you need to also learn how to address your fellow lawyers, your opponent, and also counsel for on the same side. Let's say there are many parties, they are always your learned friends. Because in Malaysia, there's no separation between solicitors and barristers. We are fused profession, so all lawyers are your learned friends. It doesn't matter whether you think they're not learned or not. Right? This is being respectful. Yeah. All right. So fourthly, right, listen, then speak. Listen to speak. So don't interrupt judges. They hate that. Don't interrupt your fellow lawyers. Even the opponent whom you may not like. So know when to stand up, when to sit down. So also when the judge comes in the room, stand up, when to bow, when to sit down, when your learned friends addressing the court. If you must say something, let's say you want to raise objection or something, right? You stand up, your learned friend will sit down. So these are the basic kind of courtroom etiquette. So that is just between the lawyers only, but also the client and the witnesses. So clients who come to look at the proceedings, witnesses who come to testify, they also need to be briefed of the proper courtroom decorum, dress nicely, how to address, where to sit. Always put their handphone on silent. Because we had one situation last time where a chief judge, was one of the people sitting in the gallery behind that, in the middle of the federal court hearing, the handphone went off. He just exploded. He threatened the person, to put them in the lockup, for contempt. So try, make sure, keep the handphone on silent. Make sure your witnesses do that because they probably won't know sometimes. Then of course it's a matter of, it's not just courtroom conduct. I think when you are doing your courses, your LLB and later on CLP or whatever other, or GDLP or the English party, you will be reading up a lot on rules of ethics. So kind of bear that in mind. But because here we're talking about courtroom, we're talking about litigation. So one of the points I would say that to bear in mind that next time if you do come to practice or you are already practicing now, try not to embarrass your opponent. Try not to be unnecessarily difficult, because even though the process which you are in is adversarial in nature, try to keep the fight in the court. So there are instances, of course, where where lawyers can't keep their cool and they continue shouting at each other even after the judge has left. There are also instances where lawyers punch each other in front of while the judge is still sitting there. So those are thankfully very rare instances, very rare. But you remember to always maintain your composure, keep cool, maintain composure, keep calm, because it really is important to do that. So try to keep your relationship with opposing counsel cordial. After the hearing, take him or her, take them out to tea, take them for coffee. Give them time when they need it. Sometimes we are very busy, we're under stress, so sometimes we just cannot file something within time, like an affidavit. If you file within 14 days, sometimes you have so many cases. The other side calls you up, says, "Can I have a little bit more time?" Don't start suspecting they are up to no good. Just give it to them. It's easier if everyone lawyers treat each other, with nicer, is it? So, yeah. So at the end of the day, because you need to take care of each other, because at the end of the day, right? Clients will leave when the case is done, but you will see the same opposing counsel in other matters. Yeah, you may not see the same client, but you will see the same counsel again and again. And if you're in here for a long time, you will be seeing the same guy for the next 30 years. So, if your relationship is very bad with him, right, it's going to carry throughout you won't want that. It's not going to be pleasant. It's already a stressful enough, kind of work without the additional, stress. Is it? So I would say that. So this, you also remember that the same counsel may appear, for another party in the same case as yours. Is it? So this could be this person, right? Could also be your could be appear on the same side as you in the future case. They are your mentors who will advise and teach you. They are the instructors also who will point you, when you need the work. They are the senior counsel who will bring you in the team for matters beyond your experience or expertise, or simply when you're overwhelmed with time. So they are your counselors who will listen to you after you had a bad day in court. So, so remember, this is something that I notice a lot of lawyers, especially junior lawyers, forget, that in the heat of the moment, right, they think of their opposing counsel like their enemy. They are not your enemies. So, so that is, I think, is quite important. So because most of all, right, you'll find that 50% of the stress and anxiety in litigation will be gone, right, when lawyers on opposing sides are more respectful and kinder to each other, within reason, of course. Now, I say within reason because if the other side asks for an extension of time, for the 5th time or something, I want to file my defense, I've asked 4 more times, I want another 2 more weeks. It's not reasonable. Then you should put your foot down. So do not abuse or take advantage of such kindness. Or you have to push back if you're being taken advantage of. So within reason. Right? Okay? So that's all I have to say.
Yeah, I think I agree with the part where you said that all lawyers should treat each other with respect, and it's very unnecessary to act hostile towards each other when there is no reason to be, because like you said, there's a lot of stress already. Like no one has to add on more to the stress. So I really I really like it when you said that.
Yes, because one thing we hear a lot, right? I have not personally practiced in KL, but I've heard that in KL litigation is very stressful. This is part of the reason, the lawyers are just being very difficult with each other, and that's also they raise all sorts of unnecessary objections, and that's why that also pisses off the judge as well. The judge who has to deal with unnecessary objections, they are so they are really stressed out. Now you add onto it, it doesn't help the whole process forward. They end up playing the game for the sake of playing the game, not realizing that that's actually an end. At the end of the day, you're here to resolve disputes. For me, I don't like to use the word justice. I don't know what it means. This justice is word, but certainly what we are here to do, as principally, is not to litigate. Although we talk about civil litigation, right? What we are here to do is dispute resolution, and dispute resolution means, right, resolve dispute by any means. If you have to settle out of court, if you have to take them to mediation, you do that. You don't go and fight for the sake of fighting, for fun. So that is something which sometimes I think litigators in their they forget that's their main purpose. That's their actually that's their job. Yeah.
Yeah, that's true also.
Yes.
So, as we know, the examination in chief, cross-examination, and re-examination are important aspects of a civil trial. So, and a lot of people usually, like especially for law students, they usually only know that part of a court trial case. Like, as you said just now, they don't really know what actually goes on behind the scenes when it comes to preparation of bundles of pleadings and other kinds of documents. So can you tell us what are some important tips or important things to look out for when a lawyer conducts a trial? In order to conduct a successful trial, what does a lawyer have to look out for?
I actually only have a very short answer to that. I think, as I said, I've taken you through the 5 areas generally, right? And essentially, the trial process is really only 20% of that. A lot of the work is done behind the scene, So, my main tip, right, which I'm going to say is this: preparation is king. Let me repeat that: preparation is king. So know your facts, know your issues, read those pleadings, familiarize yourself with the documents, prepare those witnesses well. Don't leave it to the last minute. I cannot stress it enough. Now, there are no shortcuts to this process, no tricks. You just need to know your case very well. Because once you know all that, right, essentially everything flows from there. So when you talk about cross-examination, now cross-examination is probably the most tricky part of the trial process, is it? But being able to do that well, right, largely springs from you knowing your facts and your documents very well. Now, for example, right, if you may not have much time, sometimes you have to think on your feet. This is much more so, right, for criminal trials, but it also happens in civil trials. That let's say if you have a witness, right, who says something, for example, you ask him a certain question, and he or she, right, answers in a particular way, and you realize, right, hang on, this answer doesn't sound right, is it? Doesn't sound right. But then you need to know why it doesn't sound right, and you need to know that quickly, is it? Because you cannot be telling the judge, hey, my lord, can you just stand down and go and have a smoke, right? I'm going to check my documents. You cannot, so you have to know your facts. So let's say if you know what he said, right, he is referring to one letter or whatnot, and then he says something which is not quite right, you instantly have to add a question and say, Mr. Who and Who, if I can refer you to this document, right, will you agree with me, right, that this is not what you said in paragraph 2 of this letter? So you have to know, and the only way you can add that question so quickly, right, is because you know, right, and you have read that paragraph 2 of that letter, and you know what he just said, right, is contradicting paragraph 2, right? So so that's how you need to know your, need to know your things quite well. So again, preparation is key.
Yeah, I agree with that too. I think it's very important. I think a lot of law students also tend to forget that as well. So I think when we go into practice, we will like try to remember it. That preparation is very important. And also, since you said earlier on, right? I think in response to the first question that you have this fear of not being able to speak in front of the judge in court, right? We all know that anxiety or nervousness is a very, very common and prevalent issue for law students when it comes to advocacy practice, especially in mooting competitions. So since you had to deal with this, before you step into practice, how did you actually deal with it, or at least how did you cope with it along the way?
Well, as you have known, that this question is actually quite personal to me. So what I can say is that, right, it gets better with time, but it never really completely goes away. So now even senior counsel of many, many decades of experience, right, get the butterflies before the commencement of the hearing. That's only human. And the waiting makes it worse. So imagine if you wait for 7 hours, right, a lot of things goes into your mind. The human mind, right, sometimes we call it the monkey mind, because you can't, it's a lot of, it does things whether you like it or not. It's very hard to control, you see. So I would say that, but I don't think that anxiety or nervous is necessarily a bad thing, because a healthy bit of fear and anxiety keeps us focused and cautious. It keeps you on your toes, What's worse is like you have no anxiety whatsoever. Then you think like that only happens when you're overconfident. So now that happens sometimes even to, let's say, if I've seen it before, very senior lawyer, maybe they want to help somebody or a relative or whatnot, takes on a very small matter, magistrate court, and they go in, like that, and then they get caught up, and they get very annoyed, and angry with oftentimes the junior counsel at the lower court, because they feel, they have lost that sense of fear, that anxiety, that caution, so as a result they go in basically overconfident, and they get caught out because of that. So if it's excessive, then it becomes debilitating, So now I think the best antidote, right, to anxiety and nervousness is actually preparation. Again, I said that preparation is king, right? So if you are well prepared, you will find that the moment the trial or hearing begins, you will find it and even begin to enjoy it. So now, if you are well prepared, if you are not well prepared, the judges will notice it, right? And start asking you questions, start looking for all these weaknesses in your arguments, right? And you're going to start panicking. The other side, this is contentious. Remember, this is not like, the other side is not a friendly party. So if you give them an advantage like that, right, if they're sharp, they will exploit it. They will exploit it. So now if you find that you're in that situation, your anxiety is going to turn to full-blown panic, You won't want to be in that position. And obviously, when you're in a full-blown panic, right, you're all over the place, and as unlikely the case is going to turn out well for the client. Unless your case is really, really strong and obvious, then in which case, it doesn't matter what the other side does. Even the other side is a Queen's counsel, and you totally mess up your case, you still win. But that is extremely rare, and you shouldn't rely on that being the case, right? So, so that said, right, you cannot foresee everything that will occur during the hearing. So now that comes with experience. So my second recommendation is that you will try to gain that experience. To do that, you need to take up cases. You will be not afraid to progressively take up bigger cases or to start venturing to new areas you're not familiar with. But in small steps, if possible, try working with more senior lawyers if you have access to them. So I know, of course, what I'm saying here sometimes may not be, but this is ideal. If you have that kind of situation, try and make use of it. So because as you do more and more, your confidence will grow, and now with your growing confidence, your anxiety and your nervousness will become more manageable. But in my case, that's what I found also, that as I that eventually my stabbing problem just went away. The more sure I was, the more confident I was, the more I was in control. So these days, even though you may hear me having sometimes a slight stammering, right, but I won't have, it's not debilitating anymore. I can do this after all. I can talk to you. I don't know who else, how many more people are tuning into this, and they're all watching me, listening to me speak. And I don't stop speaking. These days people say I talk too much. So yeah. So right, so yeah, so it helps lah. So I think beyond that, I think I'm confident, right, that now all of you here, must have your own personal ways of managing anxiety and nervousness. Now you're all law students, you're graduates. You are. That means one thing. That means you are basically, among your cohort of students moving up, you will need to be of a certain level in order to enter, and then to succeed, and then to graduate with a law degree. So that means, right, you already have that tools, right, in you, right, to how to manage, all those late nights, all those exams. They have given you these tools. Now these same tools will continue to serve you. As you notice that as you go for hearings, right, they're not too different from if you go for for an exam, it's the same preparation, except now it's a bit more trickier. But if you do a mood, right, you get the same feeling. You're going to have a judge, and you're going to have an opposing counsel who tries to sabotage your case. So that kind of thing is an experience. It helps you, do more of it. The more you do, the better you're going to get. Just like anything that you practice it. So yeah, so that is ultimately what you should do to manage the situation.
Yeah, first of all, I agree with you, Mr. Lau, for saying that nervousness and anxiety, at least we have a bit of it, so that we are aware of what's coming to us, so we can prepare for the cases for the cases that we are doing. Only that we have to control it, not so that it would not be too excessive, and that in order for us to do that, we need experience, we need preparations, which is good lah which is a good info for the student to help us, especially whenever we go, those who are going for mooting, those who are going to have exams. We usually have that, but it's a good info for us. So, Mr. Lau, what are some of your personal strategies in navigating through cases brought to you by your clients?
Well, I'm not sure how would you say what you call a strategy, but if I have a favorite strategy, if I could call it that, is that it is that we must get I must get the story straight the first time. That means that from the time of the very first interview of the client. So my personal pet peeve is when clients keep changing their stories, or when their documents contradict, right, what they are saying. That is very bad. You see, so they, because at the end, remember the whole process, it begins with your pleadings. So when you draft a writ of summons, when you draft an originating summons to start the case, your story has to be there. From the facts, right, flows the issues and the law, and from that you know what you want the court to give to you. See? But if your facts are wrong in the first place, right, everything that flows after would either be wrong, or they would be very, it won't be smooth. So imagine if you do it. Of course, there are ways to remedy it. For example, if you draft a statement of defense and you have all these wrong factual matters, you can always amend it. Of course, the rules allow you to amend it, but it doesn't mean, right, that you should do that, because that creates a lot of stress and anxiety for yourself. So that actually in a way also ties back to that anxiety question. Because if you get it right from the first time, you're going to have less work to do later on. So when you try to amend those applications, sometimes, right, you get very nice opposing counsel, right? They realize there's not much issue there, they'll just let it go. But sometimes you're going to get the more difficult ones who is going to fight you every step of the way. Then in which case, you're going to run the risk of a judge agreeing with them and not allowing your amendments, in which case you will be starting a case, right, on the wrong foot. So it's very hard. After that, you may have to withdraw your case and file a fresh one. But if you do that, you might incur cost penalty, and then you have to explain to your client, right, why they have to pay this 5,000, 10,000, right, for filing a fresh case. Which, like I say, all these complications down below creates a lot of anxiety unnecessarily. You can avoid them by making sure you get it right, or as close as you can get it. Not to say it won't happen. Of course, sometimes clients forget the story. Sometimes there's a letter that they issue which is not in their favor. They don't know. They discover it later on. It happens. Can't be helped. But as much as possible, get it right as early as possible. So here's the thing, right? Sorry, if I can, I just have a safety pause.
Yeah, sure.
So right now in law exams, now most of you are law students. Now in law exams, you are typically given a scenario question. So a scenario question is something like, for example, Miss X comes to you and tells you Mr. Y has parked his broken down tractor on her front lawn, but Mr. Y had gone to climb the Kilimanjaro and won't be back for 3 months. Advise Miss X. You see this scenario here, there is no possibility that this set of facts is wrong, and there's no possibility of misinformation or disinformation. This is not the case in real life. In real life, you don't have this neat question of fact, and then the lecturer tells you, "Oh, just apply the law to the facts." The facts sometimes it comes in trickles, so you have to keep banging the judge, bang the client, to keep telling, make sure their story is correct. But most of the time, civil litigation, the good thing is that clients already have their story straight most of the time. Documents will be there, and you will know quite early on whether you have a good case, bad case, in many times. So, but having said that, you still must bear this in mind, because what your advice on what to do next and how to plan the rest of the litigation process depends on getting the facts right. So if they are wrong, you're going to advise the client wrongly, and then that one wrong thing will lead to the next thing. So,
Okay, thanks for that, Mr. Lau. So recently, right, there's this article talking about how a lot of junior lawyers in Singapore are quitting practice because of issues with work-life balance, long and demanding hours, workload pressure, and mental burnout. So what are your personal thoughts on this? Like, have you ever thought of leaving practice because of any of these factors?
For me, I have not ever thought of leaving practice because what do you call it, work-life balance, long and hours, workload pressure, and all that. But I think the most difficult thing I had to, which actually occurred to me, wanting to leave practice, right, is actually outcomes. Let's be honest here. When you do litigation, right, one party will win, one party will lose. This is a win-lose scenario. It's not a win-win scenario. It's a win-lose scenario. Someone has to win, someone has to lose. Now, how are you going to behave or react when the case goes badly for you? So to me, that is a very difficult aspect of practice for me, which we have to get used to winning as well as losing. So there's sometimes, right, for lay people, they have this impression that there are lawyers out there who never lose their cases. That is not true. It is impossible if you have a senior counsel, right? A senior counsel is just someone who has lost a lot more cases than you have, because that they have to pay the piper's price to become so good at what they do. They didn't get there. They weren't born that way. They put in the hours. They lost their share of cases. They learned, and then they got better, right? So to me, I think if you're talking about the Singaporean lawyers, now I have a nephew who was in a Singapore firm. He's not a litigation, but he was in the international firm, an American firm, a very big one. And his work-life balance was completely out of whack because they are expected to have Zoom meetings at 3 in the morning, because they are expected to have to get things ready, right, by 4 a.m. on the Saturday morning. Because why? Because of there's so much pressure on them, and because their clients are located on the other side of the world. If you are dealing with an American-based client, you obviously have to follow the times, because the client is not going to wake up at 4 a.m. for the lawyer. The lawyer, is waking up at 4 a.m. for the client, right? So there's a lot of this work-life balance things being thrown out of whack. They are paid very, very well, mind you. This is not in dispute, but it's a trade-off. It's a trade-off. So you have to think in terms of when you what people don't think about often, that they would name a price. They would say like, oh, look at this this as associate in Hong Kong in Freshfields. Look at this one. They earn so much per month. They earn as much as a partner does in a medium-sized KL firm, even though they are just a associate in LA. But they don't realize, right, that two things: the cost of living is so much higher there, and secondly, they don't realize, right, that they work on billable hours. Here we charge clients based on lump sum. Over there, it's based on billable hours. Now, if it's on billable hours, you calculate, right, your dollar cost, you get a certain amount, and you're being made to work 10 hours out of 24 hours, you're expected to wake up at 4 a.m. You can just take all those working hours and divide that, right, by how much you're earning to know what is your actual hours. And these people will sometimes find out, right, that these law firms are not stupid, Those partners are not stupid. They are paying you exactly what you deserve for giving up a lot of things, including your health and your happiness, in that while. So if for a lot of young lawyers, they don't mind that, at least for a few years of their practice, I think that is fine, as long as they can put up with that. But it's hard to see how they can continue with that kind of work-life balance, right, until they are like 50 years old. Just can't see that happening, because a lot of them is going to pay the price later on. Health problems, family problems, some of them, they face these issues. It's real, it's true. So one of my friends, last time a Korean, South Korean lawyer, she's not living in South Korea. She is Korean, but she was working in a firm in Seoul, and the hours were so crazy. Basically, she hardly knows the inside of her apartment anymore. So the firm actually gives her this card. This is card, everything is paid for, so you can eat in any restaurant you want. The firm has its own gym, its own pool. It is like everything is there. They have sleep pods, so you can catch a nap inside there and whatnot. But here's the thing, because it is the work-life balance is so out of whack. They don't see their families, don't see their partners, so they are stressed out. They get ill. There's a lot of extramarital affairs going on. And that why does it happen? Because you're literally, people joke saying that, this person is my work husband, my work wife, and that joke actually literally becomes true later on. They are more than a work wife. They literally become the wife, because the wife at home is less of a wife than the work wife. So because of that, so yeah, that is certainly a problem in some of the big cities, and some of the big firms, especially the multinationals, some of these big firms with with like 5,000 lawyers worldwide and all that, right? They do have this problem, so we bear that in mind.
Yeah, it's really sad to hear that sometimes, like in the really big cities, a lot of the law firms, their work-life balance is quite, like you said, out of whack, which is truly sad. Like even for myself, sometimes even from time to time, I tend to think whether I really want to venture into civil litigation or not, because of several stories I've heard about how in legal practice it's usually very stressful. You get a lot of mental burnout, So sometimes I feel afraid also, as to whether I really want to venture into it or not. But for me personally, it doesn't really mean I'm very close to it. Like, I'm still open to exploring it.
But let me correct you there, right? The two examples that I gave you just now are not litigators. The one of them is in banking, doing banking documentation work. The other one is doing corporate. So neither of them is civil litigation. So you can see that this work-life balance has nothing to do with it. It's actually it is the function of the career they chose itself. Because litigation, one type of litigation, in terms of the time compared to the corporate conveyancing, is that corporate conveyancing, right? They have more planned hours. They know how long they'll be there. They know when they have their meetings and whatnot. Litigation, right, moves like in fits and starts. It's like you just like me like I can go through like few weeks, right, of non-stop hearings, and I would have a complete out of whack, in terms of that. But then you can also go through like few weeks, right, where you don't have that much to do, so it tends to go up and down in that kind of way. So litigation is a bit different in that way. So I think time management is important, but oftentimes litigation, right, is guided by the courts, is guided by the schedule of the courts, guided by the schedule of the arbitrator or the other decision makers. Because but on the other hand, a lot of the judges are usually quite reasonable. They will ask you ahead of time. They will say, "Can we agree on the trial dates on this time to this time?" And they will ask the other party, and the other party said, "I'm away. I'm actually traveling during that time." And the court will normally be quite happy to fix the time which is suitable for everyone. That happens most of the time. Of course, sometimes you have horror stories. There are horror stories, of course, where unreasonable judges insist that a lawyer cut short their holiday, or they fix the trial right one day after they have come back. So leaving them with no time to prepare. Such things sometimes happen. There are horror stories, but just like any, I think when you're dealing with human beings, right? You don't expect 100% perfection. There will be times that are like that, just like in any other thing. No different in litigation. Litigation, I say, is about preparing, making sure you're well prepared. And the rest should take care of itself.
Yeah. Okay, so I have another question also actually, and this one I'm quite interested lah. Just wanted to know a little bit.
Okay.
Do you think that opposing lawyers as well as clients in Sabah are more friendly or easygoing compared to those in KL? Like when it comes to compromising or settling, will you say it's relatively easier to do it in Sabah compared to West Malaysia?
Well, I have no personal knowledge, because I have not actually practiced in KL before. But I'll just give you some hearsay, based on what my friends, colleagues who have gone there, and I know a lot of KL counsel, and they do tell me that their conflict levels are much higher over there. That's what they tell me. So my experience is the same. Like the example that I gave you about the judge who came, and she was very sweet here, but she was very nasty over there. You see, in that particular case, right, my insurance solicitor had told me that he said, "Look, I think you should raise this objection within the first 10 minutes, because when this objection goes out, right, these judges, he said, are so overworked, right, and overwhelmed that they will just cling onto this objection and throw the whole case out, and then we won't need to deal with the rest." Right? That's what he said. Now, I totally respect his opinion, and I agree with what he says, because he knows this judge. Now, but in the end, I didn't agree to go that way. And the reason why is because I was telling him, I said, "Look, this may well work, because it is so common, right, for them, let's say, to raise an objection that the judges won't think it through, because the objection that you're going to raise, right, if you think about it a bit deeper, you will start seeing, right, there are a lot of problems with it. So, but if the judges are highly stressed and they're not going to spend a lot of time, right, analyzing it, they may very well grant you and then throw the case out, So, what I was telling him, I said, is this. I said, but here, when you actually come and witness the hearings in Sabah, in KK, you will see that the judges tend to be calmer, and they tend to give counsel a lot more time to submit. Now, if that happens, right, the judges are going to quickly discover, right, that your objection has no merit, or at least there are some weaknesses in it. So my KL counsel told me that in KL they won't have the patience, right, to take all the way there. So this is something to me is a very interesting experience, that example that I gave to you, because here you are dealing, my client solicitor was a very experienced litigator, and he knows what he's talking about. So this tactic, right, this strategy which he employs, right, works over there, because judges wants to dispose of the case as quickly as possible. There are too many matters, they are overwhelmed. Judges are human too, so they don't want to be going home, right, and thinking about their case. Unfortunately, they will still do that, no matter how hard they try, but they will. So they want to simplify their lives, you see. They may well be tempted to take the objection and just go with it instead of looking for it. But when the matter proceeded in KK, and the same judge, right, was so patient, even though it's at 4 p.m. Mine is the last case in the list. They are tired, they had a long day. She was patient and she listened to everything that I said. So later on, I was discussed with my insurance solicitor, right? He was saying that, yeah, I mean, that's the thing. If they are so patient here, so if I had raised an objection, right, the judge would have realized, right, after some realized that it doesn't have a very strong merit, in which case, right, my objection will be dismissed, and the judge is going to have a bad impression of me, isn't it? The judge will be thinking, hey, he is like raising some, nonsensical matter just to throw us off the track, you see. So that means I may lose some points with her, and which, all things being equal, right, the case, she might not decide for me, you see. It might affect my chances. So I think that is to me, this particular example, right, kind of gives me some insight as to the kind of how they practice over there. So certainly in Sabah here, in KK here, as I said, a lot of the most of the lawyers here are very reasonable. They're quite easy to talk to, and we take care, because it's a smaller place. We see each other more. We take care of each other more better lah. Not to say, of course, these disputes don't happen, but certainly I think based on what I hear, life is better. Yeah.
True. So my last question on this session. So, what is your advice to those students who wish to take the honorable yet challenging road towards becoming a civil litigation lawyer in the future?
Okay. I think, right. Well, I think generally speaking, I think like I've already covered quite a lot of those points earlier about the making sure you get your decorum, your etiquette right. The preparation must be there. Those things. I think once you have that, of course, you are quite in a good place already. But I would like to add, of course, right, that being still law students or junior lawyers coming into practice, you are different generation. So that there are some concerns that you might have to bear in mind moving forward, you see. So the industry is a little bit different now compared to last time. I think post-pandemic, a lot of junior lawyers are having harder time finding work, harder time finding placements, because obviously a lot of law firms are financially impacted as well. So I think there's a time of uncertainty for junior lawyers coming in, for one thing, and also there are changes in terms of technology also. If you during my time, we were still in the transition process. So I was trained, let's say when I was doing legal research, we were trained to do research physically, look for the Hallberries, to look for the Malaus Digest, do all these things. But at the same time, we are also taught, right, to use the LexisNexis, use at least all the tools which you're all using now as well to do research. So I was a transitional generation. The earlier lawyers from the boomer generation, they would have absolutely no exposure to the electronic search process research totally. But I think for you guys, you have no more. They don't even teach you much on doing physical research anymore. It's all online. And now of course we are moving towards natural research. So there's been there has been services now coming out, right? In the US, in other more advanced jurisdictions, right, where the research can be done through natural language. You don't even need to learn Boolean operators like all the and or all those things. You can actually ask a question as if you're asking your associate, and the AI will figure out what happens next. Now, this aspect of the legal tech, right, the AI and the MI aspects, right, I cannot emphasize enough, that I think as young lawyers come into the picture, you have to be on top of these things, that so when you choose, right, where you're going to go next, right, you have to have some idea, and not to be end up in an area that is in the sunset area, like for example, like I think some of the very basic conveyancing, right, there are a lot of AI apps, right, and software that can do the work better than actual human conveyances. So I think there is a transitional period going through here, which I think we need to bear in mind. Connected to that also, I think I'm aware that one thing quite different from my time and your time is that during my time we are not taught to sell ourselves, but some of my junior associates have told me that they were even taught to set up LinkedIn accounts. They're taught to write up their profiles. They are asked to create a social media presence, and I've seen that a lot. I noticed this on LinkedIn. These young lawyers, right, who take pictures of themselves and say that I've done this and this case. This is what happened and all that. And to me, that is quite remarkable. I'm not quite sure at the end of the day how effective that is, because if 3,000 young lawyers have 3,000 LinkedIn accounts, right? I'm not very sure who pays attention to so many. There's an information overload going on there. So, yeah, I think so certainly the world is a bit different compared to the time of the senior lawyers. Their world and your world is going to be a bit different, moving forward. So another point I'd like to add is that, right, even during my time, right, we started talking about taking multidisciplinary approaches. So that means, right, you don't only approach it in the old way, just by, let's say, right, resolve a thing through a legal way by just one method. There is other, for example, during my time, myself, I'm trained in public policy, and we have a different thinking process. So, for example, because I started off as a policy analyst, so when I approach the law, right, I don't think of law first. I would think in terms of purpose. So it's a purposive kind of philosophy, in a sense, like when you apply a law, or we say a law is like this, my thinking is, what does this law do? What is the purpose? Why was it enacted? It doesn't. These are man-made things. They don't appear out of thin air. It must be there for a purpose, and that purpose is a policy purpose. Laws, right, are tools that serves a policy purpose, and that is something which I think judges, right, in very advanced jurisdiction, they realize that. So if you look at apex courts, right, judgments in more advanced jurisdictions, right, they will discuss public policy in great detail before they adopt a new law into, let's say, if you hear about a new law in a different country, and say, oh, in this and this country, they apply the law in such and such a way, but then someone then takes that principle and applies it in Malaysia, and they say that let's apply that law here as well. But we have prepared to think that this law is here for a purpose. It is created by policy people, right? And it's not one judge. It is a whole group of us doing it. We do research. As far as we do research, we do statistical modeling. We interview many people. We do focus groups. And we find that maybe if we pass this law, this is one way to achieve a policy objective. So when we apply to this country, right, you have to bear in mind that this law, right, sometimes is not applicable here, because it's a different policy environment. compared to, so this is something moving forward, right? I think Malaysia, I think as we evolve to be more aware of this. So like just, I think 2 years ago, before we had the Singaporean chief judge, he came to give us a talk about public policy. And that is something I thought was quite remarkable, because before that time, right, you don't see it much in Malaysian practice, like, why is the laws are made, where they simply just blindly just apply the law. So I think, I think for young lawyers coming in, right, I think you are going to come into a more complicated environment. It's not like the environment of our predecessors, where there's only like, you come to KK or something, there's only going to be like 10 litigators and the same 10 going round and round. You're not going to have, you're going to have so many of us. It's more complicated moving forward. So yeah, I think as young lawyers, you need to bear in mind that is, not only what you choose to do, right, but what area you choose, because even in civil litigation, there are many subsets. For example, one area I think you should all think about a bit is mediation. Because mediation is starting to be pushed very much in Malaysia. About 2 years ago, I think, maybe more than that, in 2018 or 2019, I remember, there was a Singapore Convention of mediation, which many countries signed on, to make mediation settlement agreements, right, enforceable for commercial matters. So although Malaysia has a 2012 Mediation Act, right, but there was, people just didn't believe in it, they didn't think it works, right? So, but because of the pandemic, right, the government has passed this COVID-19 Act, among other things, they actually made mediation free, for certain disputes. I think, if I'm not mistaken, under 500,000. So, so that is one area where there might be a growth area moving forward. A lot of the senior lawyers have a harder time adapting to this, because mediation is essentially different, fundamentally different from litigation. Because in litigation, right, we always talk about rights. We always ask, right, what's your right? Is my rights being infringed? But in mediation, right, we are not so concerned about what are your rights, but we are concerned about what are your shared interests, whether you have common grounds. What you want to get, right, is that so-called win-win scenario, right? It's very cliche, but that's what you want to do. You want to maintain the relationship. You don't want, if you have a lose-win situation, right, you end up hating the other guy. It's the end of the relationship. Mediation allows a way out, and right now there's a lot of push. Recently, I think just last week, there was a new circular practice direction that came up from the CJ, from the chief judge, where they are bringing in mediation into the court process. Before that, right, we had something known as a court-assisted mediation, where a judge will sit in, but now they are extending that, right, to include maybe private mediators, so yeah, so that is actually a growing area. So like, just like arbitration as well is also been around for longer. It's being adopted more. Malaysia in 2018, right, amended our Arbitration Act to make it compliant with UNCITRAL model law. So it's essentially international standard now in terms of our arbitration practices. So these are areas, right, which I think as junior lawyers, right, you may need to consider if you decide to come into practice, because of the changing environment of this of practice.
Okay, so thank you, Mr. Lau, for the really eye-opening, very deep and insightful discussion on the practice of civil litigation. Definitely, there are unlimited options when it comes to this area, because there are so many practice areas to choose from. Like, civil litigation is really wide. So now is the time for our Q&A session with the audience, and I will pass this time to Ledgerod.
Thank you, Brenda. So, hello everyone. I'm back, and I will be conducting the Q&A session for this afternoon. You can now type in your questions to Mr. Lau in the chat box, and I will ask them on your behalf. So, Mr. Lau, we have Samuel here asking. You mentioned that they are difficult clients. So, I would like to ask: are there any scenarios where the clients may take some time to have full trust in their lawyer, even though they have already chosen their counsel for their case?
Yes, I think it happens. You sometimes you do have situations where the clients may not have a choice. For example, when you have a client that is an institution. So, for example, if you have an organization where their bosses have decided to retain a certain firm to act for them, so all these cases, right, that which they have will be given to these certain firms on their panel. Now, in that kind of situation, you're of course dealing with maybe an in-house counsel, an officer in an organization, and the officer is your main point of contact, and they have no choice. They can't find someone else because you're all they have. Now, in that kind of situation, right, you can't simply just walk away from it. And yes, you do have to learn how to manage, right, some of these people, and that is actually more like you do have to learn through the social skills, having a how to deal, how to work with more difficult people. From my experience, yes, sometimes it takes time because sometimes you do have you have a client, let's say, they may not have trust, or they don't have full trust in what you're saying to them, especially if you give them advice, as you sometimes do, which and the advice is not what they want to hear, right? So, and if they don't want to hear that advice, right, they may, end up ignoring you or pushing you, trying to force you to do things in a certain way. And you just have to find ways to manage them. Sometimes it goes better. Sometimes you find that the cases turn out well for them, and trust is built. And after that, you find it's much easier to work with them. They will not fight with you so much. They will listen to you more, and they will take your advice. Sometimes that happens. Sometimes, unfortunately, you do have some which you just cannot function. You cannot function. And if that kind of situation, right, unfortunately, I think you would have to find a way out of that. You may have to, if your organization has other lawyers who can work better with them, those matters may have to go to those. So let's say if you are a junior lawyer, right, and you find that you may have to go and speak to your partner in charge, and tell them, look, we just can't work well together, is it? And see how they can help you out. But if you have a choice, you may want to help them, assist them to find maybe another counsel who can work better, but who have on the same psychology, on the same wavelength. Sometimes, is it?
The next question from Dylan. Given the large amount of time limits to civil procedure, when dealing with multiple cases at a time, how do civil litigators usually keep track of them?
Well, you see, what happens is with litigation, right? There is usually time, right, set both by the rules of the court and also by the court itself. So, for example, when you file pleadings, right, the rules of the court will specify how much time you have. So let's say if you serve your writ of summons to the other side, there's a set time for them to enter appearance. There's a set time for them to file a defense, and there's a set time for you to file a reply. So you are basically guided by those time limits. Now, when it comes to the trial preparation process, oftentimes the trial judge, right, will set the time, right, when certain steps need to be taken. For example, when you prepare your bundles, when do they have to be exchanged? When you file your set agreed facts issues, when should you agree and file those in? When you have those witness statements, when is the time to exchange them before the trial begins? So because all that deadlines are actually provided for you, so you just enter that in your diary and you plan it accordingly. So you know that when you pick up new cases, right, whether you can take it up or not, or whether you have too much on your plate based on the schedule, based on your diary. So yeah, so your diary is your life. Don't lose it. You know, if you lose it and you don't turn up for the hearing on that case, your case gets struck out, you're in trouble. Your client might sue you, you know, for losing their case because you didn't know that the hearing date has been set on a certain date. So anyway, yeah, keep your diary close. Get your secretary to have another set of dates so they can remind you. If you conversant, if you know how to use the apps, you know, or any software or any other programs on the computer that can help you keep track of the time, use that as well. Basically the point is use whatever means available to you to keep track of the time. But having said that, right, your relationship with the opposing counsel is also important, because if you recall what I said earlier, you can ask for time. So let's say there's a time limit to file a certain thing, and you're about to run out of time because you have matters which are clashing your timetable. Just pick up the phone, give your opposing counsel a call, explain your problem to them, and oftentimes your opposing counsel will give you the additional time so you can comply, you know, and that's where the good relationship comes in. That's why I think you need to take care of each other, because if you do that, then stress will be better managed, anxiety will be better managed. There's nothing more stressful than you have a difficult hearing the next day, right? And you also have a deadline to fulfill the next day. You know, it's tough. You know, of course you should try to do things as early as possible. You try to do it ahead of time, but that's not always possible, because sometimes when you have a lot of matters caught at the same time, you may not be able to meet those deadlines, even if you try to do it early. So that's why you need to have be open to give time and accept requests like that for from opposing counsel. Sometimes they will help you out a lot.
So a question from Granville. Granville is actually our president. So Mr. Lau, assuming that I want to venture into civil litigation as a law student, what should I do before stepping into the area of practice to ensure that I can do my best?
I'm assuming the question you're asking is based on what kind of subjects. Is that what you are asking about? What sort of subjects that you're going to take up? So I think I'm not sure, of course, like what subjects are being offered these days. During my time, there are separate courses for civil litigation, for criminal litigation, for evidence law. So I think for civil litigation, one of the most important subjects you have to do is civil procedure. You need to know your civil procedure and courses related to that civil procedure. So within that civil procedure area, so that might be matters more subsets of it, like discovery, trial process, and also appellate procedure, for example. Evidence law is also important, although not as important in civil litigation as compared to criminal litigation, but it is still important to know, because I notice also that sometimes, right, lawyers have struggled with this issue on how to get documents admitted in evidence, because they are not aware, they don't know their Evidence Act, well enough. So that is something you need to do. I think that is crucial. As for the other subjects, I think you just do what you want to do, as you like. I don't know about which university you are in, but during my time I was on UNSW in Sydney, and we are given a lot of different subjects to choose from. So their thinking is exposure over focus. So we do everything from I even did a master's level subject on state law. So I know things like the Moon Treaty, and Outer Space Act and all these things. You see. So we are given a lot of exposure in different areas. So I think other than those main subjects which I mentioned just now, right, I think get as much exposure as you can. I think someone mentioned mooting earlier on. If you are interested in civil litigation, do as many moots as you can, because that is your closest simulation to the real thing that you can possibly get. So I recall that this is one of my regrets as well at university, is that I didn't do many moots because I was afraid of stammering. So I struggled with, so I avoided that until my final year when I signed on for moot in state law of all things. So we it was a bit interesting because we had to address the judge as Your Excellency, and all the terms are different. So submissions, we call them memorials and all that. But you have to it's before the ICJ and all those things, all that. So and I thought that experience was phenomenal. So I regret not doing more of that. So if you're interested in civil litigation, try to sign on for more moots if you can.
Another questions from Elaine. Mr. Lau, is the main preparation for civil litigation and arbitration similar, and are there any additional points we need to take note of for smooth arbitration process?
Okay. The main difference actually between civil litigation and arbitration is that arbitration, right, relies a lot more on parties agreeing to your procedure. So the procedure is not so fixed in arbitration. Now, in civil litigation, in a way, it's easier because the rules are already given to you. The rules are there in the rules of court. The judge will set the directions, what you have to do when. Now, arbitration doesn't have all that. So arbitration, you have to agree on what rules to proceed with, and they tend to be different, depending on jurisdiction, depending on whether it's international arbitration. They have different procedures which you have to pre-agree. So there's a lot of things you have to agree ahead of time with the arbitrator in terms of timeline, in terms of what you have to do. Now, the other thing about arbitration is that arbitration, right, doesn't involve the Evidence Act. So so everything that all the documents that goes before arbitration, right, it goes in. There's no so much issue of admissibility of documents. Everything goes to weight, so the arbitrator can consider them based on how much weight they want to give to that evidence. So so in summary, basically, I think for a smooth arbitration process, right, I think you need to know what kind of rules which you wish to apply, agree with the other side ahead of time with the arbitrator's agreement, obviously, set the timeline properly, and basically just follow that. Personally, I find that arbitration is more, is that looseness, right? If you don't have everything agreed with that, it can be very frustrating. If you leave it later on, to do. Also bear in mind, of course, there's an additional point. This is relevant to the post-pandemic time, is that Nowadays, a lot of hearings are done online. So that's also the other issue of a virtual hearing protocol as well. So arbitration will be has its additional requirements, if you do that.
Okay, another question. Looking at the topic of ethics in practice, bar school provides many situational problems where there is a clash between a barrister's duty to the court and their client. Does this clash happen frequently in actual practice?
Yes and no. It actually generally you don't encounter so many situations where you have to wrangle with this ethical conundrum. Most of the time in practice, right? The main question that you will encounter is the question of conflict, whether or not when you take up a new case for a new client, whether or not you are in conflict. So that is essentially, once you have that cleared off, right, the other ethical issues actually don't actually happen so frequently. Now, when you talk about the barristers duty to the court and to their client, there is of course issue of the matter of candor, of course, like if you have a client who insists on having you do things in a specific way that is not really ethical, right? Then I think you should think of this not in also in terms of your your relationship to the court as well, because you are an officer of the court, so you have a duty to be honest, to act with candor, so that is not always possible, because sometimes your what your client wants may not be what you're advising them, is it? Yeah. So I think you have to advise your client in a way that doesn't jeopardize, right, your own relationship with the court, because bear in mind, right, that clients, they come and go, but you're going to be appearing before the same judge many other cases. And let me tell you this, judges remember who is which counsel is good and which one isn't. So if you have a counsel who has a reputation, right, for being dishonest, or or counsel who misleads the court, says one thing, but let's say maybe what they pleaded, what they said something, and then they say something else in the court. When you do that, right, judges, they do remember, and later on, when you appear a different case before the same judge, you may find that, right, the judge may have some prejudice against you, because remember, the judge is human too, so and they do talk among themselves. So yeah, so you have to bear in mind, that is not just, it's ethical issue, right? Sometimes it's not just theoretical. Of course, at your stage, if you're just studying in law school, it appears very theoretical, but that is a very practical reason for why those rules are set down in a certain way, why this are drafted in a certain way, because they are to avoid, right, this misunderstandings, misapprehension, and this loss of faith, right, or how to say, loss of reputation. Remember, as a litigator, right, we are not like conveyancers. You don't go out there and then, and market. Your marketing comes from, your reputation. So if you go out there and then your reputation is burned, right, it's, firstly, it's not good for you, and secondly, you may end up attracting a lot of clients whom you do not wish to serve. You don't get this reputation, and the clients are going to say, oh, hey, maybe you can get this law because this lawyer is dishonest. He for a bit of money, he will do whatever he's told. He's a prostitute. They will say that. Now, at the end of the day, I'm not saying that, right, you can't do that, but you have to bear in mind what kind of person you want to present yourself to be, what kind of clients you attract, is it? Whether you're happy with your job at the end of the day. That also goes to your work-life balance.
So we have our last question. Hello, Mr. Lau. I often feel anxious about my knowledge and ability to speak. As a final year student, what should I do to overcome this disability?
Well, as if you have been hearing me from the start of this, you know that I started off with a stammering problem. So I have a serious problem with my ability to speak. I just, I open my mouth and nothing comes out. So here's the thing. I think, and your anxiety about your knowledge and how you can present your case, that is very natural. It's very natural. So I won't call it a disability. I think if you have a serious stammering problem, as I did, I think that is a disability. But if your problem stems from anxiety, then I think you don't have to worry too much at this time. When you are young, right, when you're starting off, you're allowed to make mistakes. Now here's the thing. I just want to enlighten you, right? One of the terrible things about our education system is that you are not allowed to make mistakes. Because if you make mistakes in school, they penalize you for that. If you make a mistake, right, you lose points. So as a result, you are trained, right, not to make mistakes. But mistakes are a fact of life. And if you don't make mistakes, right, you never learn. So if you're so anxious about making mistakes, right, you're going to end up not taking up cases. You're going to end up not trying out things, because when you do that, you have failed, right, even before you started, is it? So, let me put it this way, right, as your career progresses, your level of responsibility will become heavier and heavier, right? So your cases will get harder over time, you see, and the risk to your clients becomes that much greater, right? So I think try to just push ahead, because this is the time to do so. You have more room to make mistakes now than later in your career. So as I mentioned about the moods thing, right? If you are still at the final year student, you can sign up for a mood, because a mood is a simulation. It's a simulation. It's like playing Sims. It's like building a civilization on your computer. When you go to war, your civilization is burned, right? No real people actually die. So similarly, in this case, right, this is the time for you to just test it out, to try out, because at the end of the day, the only thing you're going to lose is lose a bit of face. But come on, there's at the end of the day, your client doesn't come bankrupt. Your client doesn't get hanged to death because you make a mistake. There is no real accountability at the end of the day. It is a simulation. In other words, you are allowed to make mistakes. When you make a mistake, you just try and try and try again. And the more you do it, right, the easier it gets. So, pick it up, the opportunity. Take it up. Don't don't be afraid. Don't be afraid, because this is how you learn at the end of the day.
Yeah, I agree that we should be allowed to do, we should be allowed to do mistake, so that is how we learn. That is how we progress in life, right, Mr. Lau? So, yeah, a wise man once said that experience is the best teacher one can have. I believe that every input that Mr. Lau shared with us today is something that could only be achieved through years of practice in the industry, and we can't thank you enough. We appreciate you, Mr. Lau, for the input that exposes us to the industry, and thank you everyone for your wonderful questions. Since we are running out of time, I'll end the Q&A session here. Over to you, Brenda.
Thank you, Legerot. I would first like to thank everyone for taking the time out of your Saturday afternoon to listen in on this session. We hope that the wisdom imparted by Mr. Lau has been eye-opening for those in attendance, as it has for me personally. With that, I hope to see every one of you in our upcoming sessions. And in the meantime, take care and stay safe, everyone. Oh yeah, and Mr. Lau, we will have a photo session after a short break.
Okay.
Yes.